Douglas J. Callahan, attorney at law. Chapter 2, we talked about our rights on bottomlands and riparian rights. Now, we should learn a little bit more about the limitations upon those rights. And again, we go back to our main source, the Michigan Lakes and Streams Association. And I'm finding some information from them. And most of these things are, you'd think they'd be common sense, but there's lots of wrinkles. For example, what happens if you have your rowboat without a motor anchored on your bottomlands, which would be defined as that area between the two corners where your property lines attach to the water line out to the center of the lake. Now, that gives you plenty of room to do just about anything you want to do, but you can't unreasonably interfere with things. Among them are having your dock shaped in such a manner that it interferes with the ordinary flow of the lake. For example, you could be near a park. There could be a park on your lake, and there's great deference to the park for water skiing people and bathers and that sort of thing. And if your dock were to extend in such a way that it would jeopardize that safety, it wouldn't be reasonable. And there's a lot of interesting questions about just exactly what is reasonable and what is not. And, one of the things you ought to consider doing is just typing in Michigan water rights, and you can get just a plethora of information, unlimited. But what I'm trying to do for you is highlight the ones that you would find significant. And before we get into those limitations, let's explore the idea that water is interconnected. We have chains of lakes in Michigan, several places. Lakes connect into Great Lakes. Streams connect into Great Lakes. Rules are different on Great Lakes. What about oceans? Different again. So there's a lot to talk about in this whole lovely subject, not to mention things like diversions of water. So these are the things we'll be talking about today.